What if the legal common sense you rely on every day is a complete fabrication? That solid foundation of legal knowledge you think you have is likely built on little more than Hollywood scripts and family folklore. We're about to systematically dismantle 48 of the most pervasive legal myths that millions of people swear are true. The legal world you think you know is a work of fiction. 1. Diplomatic immunity isn't a superpower that lets you operate above the law like a Bond villain. It's more like a corporate travel policy gone wild. While a diplomat is shielded from local courts, their home nation can instantly waive that immunity for any serious offense. For everything else, the punishment isn't jail. It's a formal notice declaring them persona non grata. This is the geopolitical equivalent of the walk of shame. But instead of leaving a dorm room, you're being kicked out of an entire country. 2. A drunken Vegas wedding cannot be erased with a quick and easy annulment. An annulment isn't divorce light. It's a legal declaration that the marriage was void from the absolute beginning due to very specific reasons like bigamy or being fraudulently tricked into it. Simply regretting your vows to a stranger in front of an Elvis impersonator doesn't qualify. For that, you need a regular, often messy, and expensive divorce. What happens in Vegas, it turns out, often follows you to a lawyer's office. 3. Police are absolutely, unequivocally allowed to lie to you during an interrogation. This is one of the most dangerous legal myths a person can believe. The Supreme Court has repeatedly upheld the use of deception as a standard and legal interrogation tactic. They can lie about having your fingerprints on a weapon. They can lie and say your partner in crime is in the next room cutting a deal. They are not there to be your friend or to have an honest conversation. They are there to get a confession. 4. Believing it's illegal to discuss your salary with coworkers is a myth that only benefits your boss. In reality, for most employees in the US, it's the exact opposite. The National Labor Relations Act explicitly protects your right to discuss wages as a form of mutual aid or protection. A company policy that forbids it is, in itself, illegal. That secrecy and taboo around pay isn't a matter of professional courtesy. It's a tool deliberately used to suppress wages, and it's a direct violation of federal law. 5. Entrapment is not a police officer simply giving you the chance to break the law. That's just a test of your character, which you apparently failed. For an entrapment defense to work, you have to prove that law enforcement coerced and badgered you into committing a crime you were not predisposed to commit. If an undercover cop offers to sell you a stolen Rolex and your first question is, "Do you have it in rose gold?" That's on you. It's a legal shield for the genuinely manipulated, not a hall pass for those with zero impulse control. 6. Believing you can't be convicted of murder without a body is a trope for crime novels, not a reality in the courtroom. While the lack of a body makes the prosecutor's job significantly harder, it's far from impossible. Juries convict people of murder based on overwhelming circumstantial evidence all the time. A mountain of forensic evidence, a history of threats, and a well-documented confession are more than enough. The phrase isn't "no body, no crime." It's "no body, no chance of parole." 7. The movie trope of smugly demanding a warrant at the door is a great way to look foolish in real life. The list of exceptions to the warrant rule is long and powerful. The plain view doctrine means if cops can see a printing press in your living room churning out stacks of counterfeit money, they don't need a warrant. Give them consent? No warrant needed. And exigent circumstances like hearing screams or seeing smoke billowing from a basement full of burning evidence? They're coming in. Yelling for a warrant while you're actively operating a giant paper shredder full of incriminating documents is not the cinematic checkmate you think it is. 8. You are not automatically liable if someone gets injured on your property. This homeowner's nightmare is fueled by a misunderstanding of negligence. You're only on the hook if you knew about a specific, unreasonable danger, like a hidden tiger pit in your front yard, and did nothing about it. If your friend trips over his own feet on your perfectly level driveway, that's a personal problem. Your legal duty is to maintain a reasonably safe home, not to personally re-engineer the laws of gravity for your uncoordinated friends. 9. You can absolutely be convicted on circumstantial evidence alone. In fact, most criminal convictions are. Courtroom dramas have rotted our brains into thinking a case is weak without a smoking gun or a dramatic confession. In reality, direct evidence is rare. A solid case is built piece by piece from circumstantial evidence: motive, opportunity, forensics, a busted alibi. It's not about one single piece of proof. It's about a mountain of interlocking facts that all point in one direction. 10. The Castle Doctrine does not give you permission to booby-trap your home like you're Macaulay Culkin. This legal principle allows you to defend yourself against an intruder who poses an active threat. It does not allow you to set up an indiscriminate, automated defense system. A shotgun rigged to a tripwire can't tell the difference between a violent home invader and the firefighter coming to rescue you from a blaze. If your trap hurts anyone, you are not a defender, you are a defendant. 11. Confessing to a crime does not automatically get you a lighter sentence. The movie scene where a tearful confession earns a judge's mercy is pure fantasy. In reality, a confession is the single greatest weapon you can hand the prosecution. It's not a bargaining chip for leniency. It's you doing the prosecutor's entire job for them. A confession doesn't unlock a secret path to redemption. It slams the prison door shut and hands the key to the other side. 12. The right to self-defense is not a green light to protect your property with deadly force. This is a lethal misunderstanding. The legal system in almost every jurisdiction values human life, even a criminal's, infinitely more than your new 8K television. You can use reasonable force to stop a theft, but the moment the threat to your person is gone, your right to use serious force vanishes with them. Deadly force is reserved for protecting people from imminent death or grievous harm, not for protecting possessions from being carried out your door. 13. Believing it's illegal to read someone's diary is confusing a massive betrayal of trust with an actual crime. Legally speaking, a diary has no more special protection than a grocery list. Sure, breaking into a locked room to get it is burglary, but the act of reading itself? The justice system doesn't care. The law is designed to stop a burglar from stealing your television, not to stop your mother from discovering your terrible screenplay. 14. Attempting a citizen's arrest is one of the fastest ways to become a defendant in your own lawsuit. While technically legal in some places, it is a minefield of liability. You generally need to have personally witnessed a felony, and you must be absolutely correct. If you mistake the situation or the severity of the crime, you haven't made an arrest. You have committed assault, battery, and false imprisonment. Unless you want to be the star of 2 different court cases, just be a good witness and call the professionals. 15. You can absolutely sue the government. The idea of sovereign immunity making the state untouchable is an archaic concept. While the principle exists, modern laws like the Federal Tort Claims Act have carved out massive exceptions. It's not easy. The process is a bureaucratic nightmare filled with special rules and tight deadlines designed to make you give up. But the king can no longer just run over a peasant with his carriage and claim immunity. He just makes you fill out a lot more paperwork first. 16. The idea that it's illegal to drive with your interior dome light on is the apex predator of all dad law. Let's end this now. In no state is this a specific crime. It's terrible for your night vision and is absolutely asking to be pulled over for looking suspicious, but the act itself isn't illegal. The officer might find something else to ticket you for, but it won't be for the light. Feel free to print this out and leave it on your dad's pillow. You've earned it. 17. Getting divorced rarely means splitting all assets down the middle in a clean 50-50 cut. Only a handful of community property states aim for that. Most operate under equitable distribution, and equitable means fair, not equal. A judge will weigh everything: marriage length, earning potential, childcare, and who brought what into the union. The court isn't using a laser level to divide a room in half. It's more like a weary parent trying to fairly split a single cookie between two screaming children. 18. Pleading the fifth is not an admission of guilt. It's an assertion of your constitutional rights. In the court of public opinion, it's a death sentence. But in a court of law, it's a smart, strategic move. The jury is forbidden from holding it against you. People plead the fifth not just when they're guilty, but when they're innocent and know a skilled prosecutor can twist their words into a confession. It's not saying, "I did it." It's saying, "I refuse to play this game when the rules are rigged against me." 19. You can, and absolutely should, yell "fire" in a crowded theater if there is an actual fire. This entire myth is built on a misquote from a Supreme Court case that was overturned decades ago. The original point was that you can't falsely shout fire to incite a panic. The legal standard is about preventing imminent lawless action, not polite silence during a catastrophe. Don't be the person who dies of smoke inhalation because you were worried about a legal technicality from 1919. 20. Double jeopardy is not a universal, one-and-done rule for crime. The Fifth Amendment prevents the same sovereign, say the state of California, from trying you again for the same crime after a final verdict. It doesn't stop a retrial after a hung jury, and crucially, it doesn't stop the federal government from trying you for the very same act under federal law. It's a protection against endless harassment from one prosecutor, not an immunity buff against the entire legal system. 21. The idea you can't go to jail for debt is a dangerous oversimplification. True, debtors' prisons are a thing of the past for your credit card or medical bills. But when a debt is court-ordered, it stops being a civil matter and becomes a direct order from a judge. Willfully refusing to pay things like child support, alimony, or court-imposed fines isn't just bad financial planning, it's contempt of court. And that is a charge that comes with a complimentary set of handcuffs and a trip to county jail. 22. The notion that silence equals consent is not just wrong, it is a profoundly dangerous myth. In any legal context, especially those involving intimacy, consent is not the absence of a no. It must be a clear, affirmative, and enthusiastic yes. Assuming permission from someone's silence is a catastrophic misreading of the law and basic human decency. The law doesn't see silence as a green light. It sees it as a complete lack of a signal, and proceeding is a gamble you cannot afford to take. 23. The myth that you can sue anyone for anything in America is fueled by a few bizarre headlines. In reality, the courthouse doors aren't open to every petty grievance. To file a lawsuit, you must have legal standing, which requires a direct and concrete injury. A judge will laugh you out of court for suing your neighbor because his tacky lawn flamingo collection causes you emotional distress. The legal system is a tool for resolving actual damages, not a publicly funded forum for your personal taste complaints. 24. The phrase, "possession is 9/10 of the law," is 100% legal nonsense. This folksy saying has the same legal weight as "finders keepers, losers weepers." In a real court, ownership is proven by cold, hard documents, titles, deeds, and bills of sale. The fact that you're currently holding your neighbor's ridiculously expensive hedge trimmer doesn't make it 90% yours. It makes you 100% a thief with a very well-manicured alibi. This logic won't fly in court, no matter what you've possessed. 25. The one phone call you get after an arrest is a complete Hollywood fabrication. There is no constitutional right to a single, dramatically timed call. What you do have is the right to an attorney. To make that right meaningful, you are allowed access to a phone. How many calls you get and how long you have is dictated by state law and local policy, not by a screenplay. The reality is far more bureaucratic and far less cinematic than choosing between your lawyer and your loved one. 26. Simply living with someone for 7 years does not magically transform you into a common-law married couple. This isn't a video game achievement you unlock with time. Only a handful of states even recognize it, and in those states, you have to actively present yourself to the world as married. This means telling people you're spouses, sharing a last name, or filing joint taxes. If your relationship looks to the outside world like you're just roommates splitting the cable bill, then that's exactly what the law thinks you are. 27. Yelling, "I know my rights." At a police officer is not the legal magic word you think it is. Knowing your rights is crucial. Performatively shouting about them during a tense interaction, however, is often counterproductive. It doesn't negate probable cause, and it won't stop a lawful arrest. More often than not, it just escalates the situation and can lead to additional charges like obstruction. The smart move is to know your rights, and then exercise them by remaining silent. 28. The idea that an undercover cop must reveal they're a cop if you ask is arguably the dumbest legal myth in existence. It is completely, utterly, and laughably false. The entire purpose of undercover work would be defeated if it could be thwarted by the simple question, "Are you a cop?" There is no law anywhere that requires an officer to blow their own cover. They can and will lie directly to your face. It's literally their job. 29. Believing that a verbal agreement isn't a legally binding contract is a great way to lose a lawsuit. While a written contract is infinitely better, oral agreements are absolutely enforceable for many types of deals. The problem isn't that they're not real contracts. The problem is that proving their existence is a nightmare. It becomes a messy, he said, she said battle where your only evidence is your own memory. The contract is valid. Your proof is just terrible. 30. Receiving a gift is not a clever tax loophole. While the person receiving the gift typically doesn't owe taxes, the person giving it might. The IRS sets an annual limit for tax-free gifts. If you give someone cash or property above that amount in a single year, you are required to file a gift tax return. Trying to disguise your income as a series of gifts from your employer isn't a savvy financial move. It's a handwritten invitation for a full-blown IRS audit. 31. If you find a chest of gold doubloons in your backyard, don't start shopping for a yacht just yet. The finder's keeper's rule is for children in a playground, not for adults in a court of law. The legal status of your discovery is a complex web of rules about lost, mislaid, and abandoned property. If an original owner can be traced, they have a claim. If it's deemed a historical artifact, the government will likely claim it. That pirate fantasy almost always ends with lawyers, not treasure. 32. The idea you can successfully sue a fast food company for making you obese has been consistently rejected by the courts. The famous lawsuits people think of were about dangerously hot coffee, not calorie counts. Courts operate on the principle of personal responsibility and assumption of risk. No judge is going to accept the argument that you were unaware of the potential consequences of eating fast food. It's a risk you knowingly accept every time you pull up to the drive-thru. 33. You cannot copyright an idea. This brutal truth is the graveyard of countless million-dollar ideas. Your concept for a sitcom about a time-traveling hamster is legally worthless. Copyright only protects the tangible expression of that idea. The finished script, the drawings, the recorded theme song. The core idea is a free-for-all. An idea is just a ghost in the machine. The law only protects the machine you actually build to house it. 34. The myth is that prenups are a toy for billionaires to shield their fortunes from so-called gold diggers. The reality? They're just smart financial planning for normal people. A prenup can clarify what happens to a family business, protect you from a partner's crippling debt, or designate a family inheritance. It's not about expecting failure. It's about having a deeply honest financial conversation before you legally merge your lives. It's not a bet against your marriage. It's just buying insurance for the car you're about to drive together. 35. Attorney-client privilege is not an unbreakable vow of silence. While it's one of the strongest protections in the legal world, it has a glaring exception: the crime fraud rule. If you are using your lawyer's advice to plan or commit a future crime, that conversation is not confidential. Your lawyer is ethically bound to protect the secrets of your past, but they are legally forbidden from becoming your co-conspirator for the future. They are there to get you out of trouble, not help you get into new trouble. 36. Stand your ground. Laws are not a license for vigilante justice. The myth is that they allow you to use deadly force the moment you feel threatened. The reality is that these laws only remove your duty to retreat before defending yourself. You still must be facing a credible, imminent threat of death or great bodily harm. The force has to be proportional. You can't shoot someone for yelling at you in a parking dispute. It is a legal defense to be argued in a courtroom, not a blank check for a shootout. 37. The phrase "innocent until proven guilty" is perhaps the most misunderstood principle in American law. It is not a social shield. It doesn't stop you from being arrested, jailed while awaiting trial, fired from your job, or crucified in the court of public opinion. It is a strict procedural rule for the courtroom. It means the prosecution bears the entire burden of proof, and a jury must begin with the presumption of your innocence. It's a vital safeguard inside the courtroom, but it offers you zero protection once you step outside of it. 38. A contract is not an unbreakable magic spell just because you signed it. Your signature is powerful, but it cannot validate the illegal or the absurd. A contract to commit a crime is void from the start. A contract signed under extreme duress can be thrown out. And if the terms are unconscionable, so monstrously one-sided they shock the conscience, a judge will invalidate it. Your gym membership contract can't legally require you to forfeit your firstborn child. Some things are just too ridiculous even for fine print. 39. Crossing a state line with a stolen car doesn't make the crime more illegal. This is a TV cop show trope. Committing a crime that crosses state lines doesn't upgrade the severity of the offense. It just changes who gets to arrest you. It triggers federal jurisdiction, meaning the FBI might take the case instead of the local police. You're not facing a tougher charge, you've just swapped a local detective for an agent in a slightly better suit. The potential prison is just as real. 40. Squatters' rights are not a secret cheat code for acquiring a free house. The actual legal doctrine, adverse possession, is a grueling marathon designed to be nearly impossible. It requires you to occupy a property openly, notoriously, and continuously for a decade or more. And in many states, you must also have been paying the property taxes on it that entire time. It's not a sneaky loophole for the clever. It's a legal remedy so obscure and difficult that it almost never works. 41. If a store accidentally misprices a new TV for $5, they do not have to sell it to you for that price. This is the official myth of everyone who has ever screamed false advertising. A price tag is not a binding contract. In legal terms, it's an invitation to treat. It invites you, the customer, to make an offer. The store is then completely free to reject that offer, especially if it's based on an obvious mistake. That mislabeled price tag is just an invitation to have a very short, disappointing conversation with the manager. 42. The idea that you can just opt out of the law by declaring yourself a sovereign citizen is a popular internet rabbit hole that leads directly to a jail cell. Followers of this myth believe that reciting specific, magic-sounding phrases can make them invisible to police and the IRS. Let's be crystal clear. This has a 100% failure rate. It has never, ever worked in a real court. Judges have zero patience for this, and all it accomplishes is escalating a routine traffic stop into a felony arrest. Telling a cop you're a traveler, not a driver, won't get your ticket dismissed. It will just get you a much, much worse day. 43. Accidentally walking out of a store with an item you forgot to pay for is not automatically theft. The absolute key to any theft charge is intent. A prosecutor must prove beyond a reasonable doubt that you intended to permanently deprive the owner of their property. If you genuinely forgot about the pack of gum on the bottom rack of your cart, you're not a shoplifter, you're just forgetful. The law prosecutes criminals, not people who are easily distracted by BOGO deals on cereal. 44. It is not a federal crime to destroy money. The idea that the Secret Service monitors the structural integrity of every dollar bill is absurd. The law forbids defacing currency with intent to defraud, which is aimed at counterfeiters. Tearing up a $20 bill in a fit of rage or using it for an art project is of no interest to the federal government. Unless you're building a life-sized papier-mâché statue of Ben Franklin out of actual $100 bills, they are not interested. 45. The insanity defense is not the get-out-of-jail-free card that movies make it out to be. It is an incredibly rare and seldom successful strategy, used in less than 1% of felony cases. And winning doesn't mean you walk free. It means you are committed to a locked, state-run psychiatric facility, potentially for longer than the prison sentence would have been. The myth is a clever ruse. The reality is trading one set of locked doors for another. 46. If police arrest you and forget to read you your Miranda rights, the case is not automatically dismissed. This is the biggest procedural myth from TV. The Miranda warning is about the admissibility of your statements. If they question you without reading you your rights, your confession gets thrown out of court. That's it. The arrest is still valid. All other evidence, physical, witness testimony, video footage, is still perfectly admissible. They just can't use the words you said against you. 47. You can't sue someone for emotional distress just because they hurt your feelings. For a lawsuit like this to succeed, the defendant's conduct has to be considered extreme and outrageous by any reasonable standard. We're talking about a sustained campaign of harassment or truly abhorrent behavior, not just being rude or ghosting you. The resulting distress must be severe, often requiring medical documentation. A judge isn't going to award damages because someone wrote a mean comment on your Instagram post. 48. Saying something off the record to a journalist is not a legally binding contract. It is a professional courtesy, an ethical agreement based entirely on trust. If a reporter breaks that trust and publishes your comments, you have no legal recourse against them. What you have done is destroyed their reputation and career, as no source will ever trust them again. The only thing enforcing the rule is the fear of professional suicide, not the threat of a lawsuit. It's clear the legal system isn't what we've been told. It's a minefield of misinformation we've been navigating blind. Now for a moment of honesty in the comments. And don't be shy. Which one of these 48 myths did you believe was 100% true until today? Let's see which lie is the most widespread. If you value knowing the real rules of the game, prove it with a like and a subscription.